Hello and welcome back to the East Carolina Law Group Self-Help Series. This is Season 2, Episode 2, and this one is entitled Understanding My Legal Fees. Now, in our last season, we did one on legal fees. We did an episode where we covered what to expect in terms of how a legal fee would be structured for a particular type of case, but we didn't go into a lot of great detail. One of the first questions that we get in a consultation is, how much is this going to cost? Well, it depends on the type of case and how the fee is going to be structured. So typically, let's talk the easy ones, personal injury cases. Personal injury cases such as car accidents, wrongful deaths, airplanes falling out of the sky, things of that nature, where there's an insurance company as a payer on one side, where it's pretty clear where liability rests. But the question is going to be, how much are the damages? Generally speaking, these are done on a contingent fee basis. Now, at the East Carolina Law Group, the way we structure our contingent fees is that if we're going to just settle the case before there's anything filed with the courts, then the fee is 1/3 of the gross recovery from the settlement. What that means is if you have a $30,000 settlement, $10,000 of that settlement is going to be your legal fees, and that comes right off the top. Now, many people go, well, why would I hire an attorney to deal with an insurance company? Well, for a number of reasons. Most commonly, what we see when folks go, why should I pay an attorney $10,000 of my $30,000 settlement? Well, what we tend to see is they come running into our office 6 months before the statute of limitations runs out and go, oh God, help me. I'm about to lose my $30,000 entirely. So it's important to remember, get an attorney involved. The other thing is, you do not know how to negotiate, in most cases, the types of things that the insurance adjusters and the insurance attorneys are going to want to see in order to maximize your settlement amount. The other thing that we see commonly that we find to be very unscrupulous with many insurance companies, particularly in car accident cases, where the new thing that we've seen in the last couple of years is where the claims will be bifurcated. What that means is let's say you're in an accident and your car needs to be repaired and you were injured in the ensuing carnage. What we've seen some insurance companies do, without naming any, is that they will have a property damage settlement that will be sent, and inside the body of the release is a statement saying that I release the so on insured and insurance company, heir successors and assigns, and indemnify them against any and all other claims. And then the next time you try to get on the phone with the personal injury adjuster, they say, nope, we're not giving you anything because you signed an indemnity agreement. You accepted the settlement. I didn't know that. If you watched our previous video, ignorance is no excuse. This is why you hire an attorney. Even in some cases where there have been big money involved that we've been involved in, we've had situations where one insurance company, say you've got more than one involved, will have a general release and indemnity that will just be a blanket release and indemnity. And after reading carefully through the fine print that we know what it means, and you probably don't, we made sure that we redact that section, all liability, and change it to this insured, this carrier. Why? Because in settlement, when you go to mediation and negotiate that final settlement with the big chunk, you don't want them throwing it back in your face going, oh, you released it, we're leaving. No. This is why you need an attorney involved. This is why you give an attorney a third. There's a lot of work that goes on. Particularly what most people don't realize is the volume of medical records, reports, accident reports, adjustments, assessments, all those things that need to go into play just in the settlement process before anything gets filed. And then you've got to front load a lot of information in the event that you would have to file a lawsuit. So personal injury is relatively easy to understand. The only thing you would really worry about having to pay out of pocket are usually things such as filing fees, discovery fees, deposition fees, expert fees. Those things you tend to have to pay out of pocket unless you're going to a firm that has a lot of money in reserve, and there's not very many of those around. So that's a contingent fee. Now, a flat fee. Flat fees are what everybody wants to have in their particular legal case. But unfortunately, there's only a handful of cases where flat fees are actually appropriate. So, usually with a flat fee, it is a one-time flat fee that a person pays for their representation, and it's usually for a limited scope representation. So, for example, a criminal matter. If you have a district court criminal matter, generally speaking, you'll have a flat fee of anywhere from $500 to $3,000. And once it's paid, it's earned, it's non-refundable, and once the case is over with, it's done. That doesn't mean you're going to have an attorney that's going to go on to superior court. If you lose, there'll be a new retainer for that. However, that's what everybody wants to have on all their cases. So they know, oh God, this is what it's going to cost me. I'm going to pay $3,000. But in many situations, because of the unpredictable nature of civil matters, civil cases are very often billed as an hourly rate. Now, what does that mean to you? Well, civil matters that I'm referring to are not personal injury cases and whatnot where you have an insurance company. And also understand that just because you may be a plaintiff in a civil action doesn't mean that an attorney's office is going to take it on a contingent fee, unless there is a willing and able insurance company that's going to come in on a reservation of rights, duty to defend, and is going to admit liability and is going to pay. It's very important that you understand that just because you may be a civil plaintiff doesn't mean you're going to get a contingent fee. As a matter of fact, the fewest cases we do of the dozens of civil cases that we handle every year, probably less than 5 to 10% are going to be contingent fee. The majority, the bulk majority, are hourly cases. So let's talk about hourly retainers. Now, one of the biggest areas of law that we practice where we see the most hourly fees is generally going to be in family cases, divorce, which are civil cases, okay? There are other types of civil cases where you will see hourly fees, such as what are called claim and delivery cases, where somebody has your things, you want them back. Usually, depending on the amount and how much is going to be contended and how complex the case is, those are sometimes going to be done on hourly fees. But for the most part, most of our civil hourly cases are family cases. Divorce, equitable distribution, alimony, child custody, especially high conflict cases. These are going to be done on hourly fees. Now, to give you an idea on what to expect, because this is always the question, how much can I expect to pay in an hourly fee for my divorce, for my custody case, so on and so forth? Well, that's very hard to quantify, and it's very hard to tell somebody sitting at our table in a consultation it could cost up to X amount of dollars. The sky is the limit. It depends on the complexity of the case. It also depends on you, the client. And we are going to talk about some things that you can do to help control your costs. But recently, doing some looking online and looking at some other law firm websites and some Facebook pages and things, I actually found a graphic that was really, really helpful and very representative and actually very accurate for North Carolina, although it was coming from a Pennsylvania law firm. And this graphic here is very representative and actually very accurate to what we see here in our contested divorce and custody cases. It's very, very close, very similar. There's a couple little differences, and I'll point those out. And this says the legal costs of a contested divorce in PA, Pennsylvania. I could cross this out and say North Carolina. It's very similar to what we see here. Generally speaking, when you have a contested custody or divorce or any kind of family case, you're going to have to engage an attorney. If you don't, you're a fool. Go see video 1. Number 2, you go see an attorney, you pay a consultation fee. If you call a law firm and say, I have a contested divorce, do you do free consultations? You're probably going to get laughed at. Because unless you're dealing with a brand new fledgling attorney, just out of law school, hanging their own shingle, you are almost never going to get a free consult. One, that signals to the attorney, if you've been practicing for more than a month, if you want a free consult, you probably can't afford the fees. Number 2, it also is an indicator, if you want a free consult, that even if you can pay the initial deposit, you're never going to be able to replenish your retainer. Initial consultation fees, $200 to $300. Now, This is fairly accurate. Here in North Carolina, in this area, especially in the 1st Judicial District, generally speaking, I see consultation fees from firms running anywhere from $100 to $350 for a consultation. That's about the average. So this $200 to $300 is pretty accurate for an average. Now, initial retainer deposit. Now, a retainer deposit is basically opening a checking account with that law firm. You're going to give them money. It's not their money. It's still your money until it's been earned. Read your retainer agreement. In our firm, our retainer agreements have a component built in that says as soon as you retain us, we immediately earn 20% of that retainer for opportunity cost. That's very important to remember. If you retain us and 24 hours later you turn around and say, oh, mulligan, I don't want to do this now. We've already started work within 24 hours. You're going to lose that 20%. Keep that in mind. So the retainer deposit for that attorney, for that contested divorce and custody, $35,000 to $5,000. That's very accurate. These Carolina law groups' minimum retainer deposit right now for a contested custody or divorce is $4,000. Now, if we have to go outside of our district, it goes up to $5,000. So that $35,000 to $5,000 is very accurate, holds very true. Okay. Attorney billable cases for work, the attorney hours. Attorney hours are billed in 1/10 of an hour increments, basically every 6 minutes. So if we do 11 minutes of work, you're going to pay 0.2 hours. It gets rounded up. So you're going to be paying $275 to $375 an hour. Again, that's pretty accurate. At the East Carolina Law Group, our base attorney hourly rate is $250 an hour. So it's a little less than this. And we do offer some pretty steep discounts depending on the situation of the person. However, $275 to $375 for the 1st District is actually pretty accurate. $10,000 to $20,000 for custody, evaluations, and trial. This is very accurate. Remember, you're paying $275 to $375. Let's even say at $250 an hour for our rate. To go to a trial on a custody case, if it's going to be a 1-day trial, which is about the average, you're looking at anywhere from 6 to 8 hours of preparation for that trial. Not to mention staff and support time build up to $85 an hour. And then you're looking at trial. And depending on how in depth, there may need to be an assistant that goes to trial to help manage exhibits. So you're not only paying your attorney's time, you're paying for the staff time and support time for your trial. It's not unusual for trials to cost clients anywhere from $5,000 to $7,000. And remember, that's just one component. Then you're going to have equitable distribution, you're going to have alimony, you're going to have the divorce. So there's going to be a lot that goes into this. Now, on our end, we do everything we can to try and minimize the amount of time you have to spend in court because it's just very costly. So we try to consolidate as much as we can. In preparation for trial and throughout the duration of a case, you're going to spend $3,000 to $4,000 in discovery. That's pretty accurate. Discovery is very involved. Discovery is where we send questionnaires, we prepare and send those. We receive documents, we send documents. We do depositions. We do everything from entry and inspection of homes. These are all components of discovery. $3,000 to $4,000, in my opinion, is a little on the light side. However, that can also kind of be wrapped into the custody evaluations. If you have a custody case and there's the need for a parenting capacity evaluation, that's going to be added into that cost. If you have a contested equitable distribution, you're going to be hiring experts to do appraisals. You're going to be hiring forensic accountants in many situations to help pull apart and figure out what your financial situation is. And all these costs begin to add up. $25,000. If you end up having to be, or if you end up being declared the supporting spouse, there's a possibility that you could actually have to pay the attorney fees for the other side. Could be up to $25,000. Then you have your unpaid time off at work, medical bills, up to $150 an hour. If a court orders you to undergo co-parenting mediation or co-parenting therapy and counseling with your significant other, your child, so on and so forth, or if you have to go to anger management and you don't have insurance to cover it, you're looking at up to $150 an hour for those things. At the end of everything, a contested divorce a knockdown dragout can easily cost $30,000 to $50,000 start to finish. And it can take anywhere from 2 to 4 years. So the information on this graphic, after I sat down and reviewed it in depth and compared it to our own last 3 years, it's pretty accurate. It holds pretty true. With some very slight deviation here and there, the overall is pretty accurate. $30,000 to $50,000 is pretty close to what you're going to pay for a knockdown, drag-out, contested divorce with custody, equitable distribution, and alimony. Does this mean you shouldn't hire an attorney? Absolutely not. Let me just tell you this much. I have had some people that have run out of here screaming when I tell them what this thing could cost. But usually, within 3 months, they're back. Why? Because the other side is usually so angry, they're going to do it no matter what. So you're either going to be on the losing end, trying to represent yourself, which we've had clients that represented themselves all the way through the process and get to the end and come running in here, help me, save me. Judge is going to throw me in jail. Why? Because I was ordered to pay $2,000 a month in alimony and I don't have 2 nickels to rub together. Well, what did they find at trial? Well, they found that I had all this money, but I really didn't. Well, if you look at the evidence, guess what? They weren't able to present any evidence. Why? Because they don't know the rules of evidence. They don't know how to present it for themselves. If you don't know the rules of evidence, doesn't matter. You can have a mountain of evidence. Well, you can have a mountain of papers that you think is evidence, but if you don't know how to have it introduced and get it admitted so that the court will consider it properly, guess what? They're not going to consider it. So it's a one-sided argument. You might as well just not showed up. Many times we'll have people come in here after the fact and say, oh, I hate that judge because they wouldn't look at anything I had. Well, who was your lawyer? Well, I represented myself. Well, you don't hate the lawyer, you hate yourself. Because if you'd have had a lawyer, they would have had it admitted and the judge would have considered it. It's not that the judge was trying to do something nefarious to you. It's that you just didn't know what you were doing. You're representing yourself. Stop being cheap. Just remember, you married this person. You found them compelling enough to marry them. You fell in love with them. You took care of them. They took care of you. Whatever the case may be, doesn't matter what's happened. If you're going to go through a contested divorce, guess what? You just bought a car, baby. So just be ready. Go get you some before your credit's ruined, before everything goes belly up. Go take out a big fat loan for your lawyer fees. Find a family member that really likes you and borrow it. Whatever you need to do. Because if you don't, this $30,000 to $50,000 could double or triple based on what the court finds when you go in there unrepresented. And it happens all the time. And I will say this much, and I've said it in my other videos, an ounce of prevention is worth a pound of cure. Because if we have to try to fix your mess, it's gonna cost you double of what it would have cost if we'd have done it to begin with. Don't be cheap. He who represents himself has a fool for a client. If you're gonna go through a contested divorce, it's not supposed to be cheap and it's not supposed to be painless. The law does not make it easy for you to basically dissolve your marriage. There are things that need to be done and duties that need to be upheld. And there's liabilities that flow from that. So make sure if you're going to go through a divorce, you are ready to buy a car. You are looking at anywhere from $30,000 to $50,000 if the case goes all the way through the trial process. The silver lining here is this. One of the things that we pride ourselves on doing is being able to get through this discovery process, distill the information that we have, look at these things in a very holistic way, spread them out, put them onto balance sheets and say, okay, here's the reality of your situation. And if you can show a good justification, we have had very good success with settling cases. Even on the day of trial, before we spend 12 or 14 hours going through the trial process, sitting down with the other attorney before or during the trial process and saying, let's settle. It's more cost effective, and 9 times out of 10, you all will be able to work out a much better arrangement than what a court is going to give you. And if you end up having to be the recipient spouse in these situations or the recipient party, the chances of getting paid without having to drag them back through another process for contempt or collections or otherwise is a whole lot easier, because 9 times out of 10, if they're going to agree to it, they're going to pay it. So just remember, once again, as I've said before, and I'm going to keep saying it, do not represent yourself. Is it expensive? Darn tootin' it's expensive. Probably costs you anywhere from 5 to 10 grand to get married. Well, it's going to cost you about 3 to 5 times that to get out of the marriage. So if you're not yet married and you're watching this, make sure you guys really, really, really love each other, and you're not going to end up split up. Put aside your petty differences once you are married. Not everything's a crisis. And remember, the worst thing in a marriage and in a courtroom, the one term that will kill you in a marriage or in a courtroom, remember that. I'm saying it over and over, just like they did in law school. I'm saying it over and over because I want to ingrain it in your head. The one term that in marriage and law school, doesn't matter which gender you are, is principle. Principle is a torpedo. Doesn't mean you got to argue over it, whether you're in court or you're just talking to your spouse, because that's that little seed, that's that little thing that's going to start that little divorce plant growing. And once that divorce plant gets growing, that's kind of a good metaphor. That little divorce plant develops into a money tree. And then once you shake that money tree and it falls, it goes right to your lawyer, because it takes a lot to get one of these divorces through. And don't think that we're profiting on all this, because the average attorney is only going to be taking home between 10 and 20% in actual profit. The rest is going to go to overhead and expenses. So just remember, if you're going to get divorced, you're buying a car. If you can get out of it for less than 10 grand, you're doing good. I'm attorney Tim Kohler with the East Carolina Law Group. I hope this video has been informative. I hope I've actually talked some of you out of divorce. And those of you who are going to end up in a contested divorce, we'll keep you in our thoughts and prayers. We'll be here for you when we need you, but just understand the situation. We want to be wholly transparent with you and let you know the actual lay of the land. This is not going to be cheap, and it is going to be painful. But when it's over with, and you'll be able to have that peace of mind of knowing it's done correctly. So thank you for tuning into the East Carolina Law Group Self-Help Series. We hope that you found these videos informative and have been informational in helping you determine what your next course of action should be in your own particular situation. If you find yourself needing additional legal help, we're available, and you can set up a consultation by calling our office at 252-453-2273. That's 252-453-2273. 2273, or you can look us up on our website at eastcarolinalaw.com, or you can find us on Facebook at the East Carolina Law Group, and we post regularly on there, sometimes almost daily. We put everything from new legal information to office closures and things of that nature, and we provide updates on things that are happening in North Carolina and in our local district. So once again, if you need to get in touch with us, it's 252-453-2273. The East Carolina Law Group, where your family is our priority.